Imagine you have committed an illegal or an immoral act, and because of that you have experienced some loss. Now, if you are going to court and asking compensation for the loss that you have experienced, and if you are asking compensation from someone else, what happens? Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Law of Torts, we were discussing on general defenses against tortious liability, and in that series, this is my third video where we are going to discuss the second major defense available with the defendant, that is plaintiff the wrongdoer. We are going to understand this concept with the help of lot of case laws. But before we get into anything, the first two slides will quickly recap whatever we have learned in video 1 about plaintiff the wrongdoer and what are the different defenses available with the defendant. I'm taking just 30 seconds for that, and then we'll get into plaintiff the wrongdoer in detail. Not taking much of your time, let's get into the first slide. Here is the list of general defenses against tortious liability which we have discussed in video 1, that is Volenti Non Fit Injuria, Plaintiff the Wrongdoer, Inevitable Accident, Act of God, Private Defense, Mistake, Necessity, Statutory Authority, Act of the State, Parents having parental or quasi-parental authority, and acts causing slight harm. This slide also we have seen in video number 1 where we have discussed all the general defenses together, and here we can understand what is plaintiff the wrongdoer. If plaintiff parks his cycle on mid of the road, now that is an illegal act. Now if someone comes and hit that cycle, plaintiff puts case against the person who has hit his cycle, the court will not take the case in the first place because the plaintiff has done an illegal act. That's how we have to understand plaintiff the wrongdoer, where the plaintiff himself or herself has done an immoral or illegal act, and after that if you are taking the case, the court is not going to consider, and that becomes a general defense for the defendant, which is what we need to understand. Let's understand the concept plaintiff the wrongdoer in detail in my next slide, and later let's move on to different case laws. To understand the concept plaintiff the wrongdoer, we need to go through the Latin legal maxim extirpi causa non oritur actio, which means from an immoral cause no action arises. That means if you have committed an immoral act or an illegal act, after that you cannot ask for any action in favor of you, which is what we need to understand. And this particular principle or the maxim is applicable in contract, restitution, property as well as trust. It is a complete bar on recovery when succeeds to prove the same. If the defendant succeeds to prove that the plaintiff has committed an immoral cause or act or an illegal act, that becomes complete bar for recovery, which is what we need to understand from the maxim extirpi causa non oritur actio. And observe one more very important thing. This Latin legal maxim was referred as early as 1775 by Lord Mansfield in the case law of Hallman versus Johnson. Now below I have given two pictorial examples to make it easy to understand what exactly is plaintiff the wrongdoer. In the first picture I am just covering one scenario, whereas in the second one I am covering two different scenarios. What happens in the first picture? There is a highway, and the highway authority has very clearly mentioned that big trucks are not allowed in that particular highway. And a truck enter into that road and gets accident. Now here the truck got damaged because there is a bridge available above that road, and if the truck owner puts a case against the highway authority, what happens? Here highway authority, being the defendant, very clearly and loudly says that those trucks were not allowed in the first place itself, because we have already put a notice that trucks are not allowed in that particular road, and the owner of the truck has taken the risk of entering into that road, which is an illegal or an immoral act by itself. So there is no question whatsoever as far as the damages are concerned. There will not be any compensation by the highway authority because the truck driver or the owner has committed the mistake by entering to that particular highway. There plaintiff is the wrongdoer by bringing the truck on the road. That way defendant wins the case. That's how you need to understand the first picture. In the second picture, a truck has gone over a bridge and the bridge has collapsed and the truck was drowned. Now here we can see the case in two different angles. First, if on the bridge, if it is mentioned that trucks are not allowed and if the truck owner has taken the risk of going on the bridge, in that case truck owner will lose the case because there is already a notice mentioned that trucks are not allowed or no entry signage was there. But even then, if the truck owner has gone on it, he has committed the mistake. So he being the wrongdoer, there will not be any matter of compensation. On the other hand, if there is no notice whatsoever as to there is no entry to the trucks and if the truck has gone over the bridge and if the bridge has been collapsed, now the bridge owner or the authority cannot put a case against the truck saying that they have entered the bridge and caused collapsing of the bridge. The court will say you haven't mentioned anything, so the truck has gone over the bridge and hence the bridge got collapsed and you will not get any compensation from the truck owner. On the other side, if the truck driver put the case, he will get compensation because there was no notice whatsoever. That's how we need to understand. Here what happens, the person who is putting the case, we need to very clearly understand who is the plaintiff and who is the defendant. The person who is putting the case is plaintiff and the one who is defending is defendant. Now the person who is putting the case himself or herself has committed some wrong. In that case, there is no question of action. Like for example, in the first case, the truck driver or the owner has entered in a no entry highway. By that way, they have committed a mistake. If now they put a case, highway authority need not to pay any compensation because in the first place, the truck driver or the owner has committed a mistake or wrong by entering into a no entry place. Likewise, in the bridge case, I have given two scenarios. So whatever is the scenario, if the plaintiff has committed a mistake, in that case, there is no compensation whatsoever. I hope that is very clear. With that, I am taking you guys to few of the very important case laws. The first case law that we are understanding to understand the concept of plaintiff the wrongdoer is Pitts versus Hunt. What happened here? Two friends, that is Pitts and his friend, had lot of drinks and after that they decided to go on a ride. Now here three major facts that you need to observe are: one, Pitts was aware that his friend is drunk and he is going to ride now. Number two, he was also aware that his friend had no driving license. Number three, he was also aware that the vehicle had no insurance. Now, even after being aware of all those facts, Pitts decided to go riding along with his friend. Now, the vehicle got accident and the rider, that is Pitts' friend, died in the accident. And Pitts put a case against the second defendant of that particular rider, maybe a family man or so. But in the court said there is no question of compensation to Pitts, who is the plaintiff here, because plaintiff himself is the wrongdoer. He was aware that his friend was drunk. He was aware that he doesn't have motorbike license. He was aware that there is no insurance. Even after knowing all of these facts, he agreed and decided to go for a riding along with his friend, which means Pitts himself is the wrongdoer and there is a lot of contributory negligence to the extent of 100% by Pitts. So there is no question of compensation or whatsoever, which is what decided in this particular case law. I hope that is very clear. With that, I am moving to the next case law. The second case law that we are discussing here is Bird versus Holbrook. We are discussing this particular case law for the second time, as we have already discussed this particular case law in my previous video, that is Volenti Non Fit Injuria, where we have discussed about what if there is no notice available. What happened here? There was a person by name Bird who had some tulip flower gardens. Now one fine day somebody entered and robbed these tulip flowers. So Bird obviously felt bad. So what did he do? He set some spring guns in his property. Now putting spring gun trap is not a illegal thing, but whenever you put a spring gun trap, you have to put a notice that the intruders will be caught with the spring gun trap. That needs to be mentioned. But Bird has not put that, and one innocent trespasser passed through that and got caught and got injured. Now Bird put a case against the person who has entered his property, but the court said as Bird has not put any notice, that becomes an illegal act. That's why there is no compensation or whatsoever available to Bird in this particular case, which is what held in Bird versus Holbrook. The third case law is very interesting. This is Ashton versus Turner. Now they both committed a crime together, that is burglary or theft, and after that they were trying to escape from the crime spot. Now here Ashton was driving and Turner was the passenger, and remember they both committed theft together and were trying to escape from the crime spot. Now here Turner was driving, at the same time he was drinking, and he was also driving very negligently. That caused an accident. The car has crashed to something and both got injured, and Ashton put a case against Turner saying that he should get compensation. The court said they were committing an illegal thing, and at that moment this has happened. Though the driver has duty of care, that question does not arise here, which is what held in this particular case law. As Ashton was also a wrongdoer in this case by doing the theft as well as knowingly sitting inside the car that the driver is drinking, driving negligently, and they are in an attempt to escape where there are all chances of accident. All of these were discussed in detail in the case law of Ashton versus Turner. This gives one angle for you guys to understand what is plaintiff the wrongdoer. I have one more case law to understand the other angle in my next slide. Let's see what is in my next slide. This case law, as I have already told, gives another angle to plaintiff the wrongdoer. This is Hallman versus Johnson. What happened here? Hallman, he was trading tea, he was selling tea to many people, he was delivering tea to many people, and Johnson came to Hallman and asked for tea. Now this entire episode is happening in France, and in France delivering tea from one person to another person was completely legal, and Hallman agreed to supply or delivery tea to Johnson. Now here, while making such contract of delivering such a quantity of tea to Johnson, Hallman was aware that Johnson has an intention to transport this particular tea illegally to England, that is taking it to England without paying tax. This much of information was available to Hallman also. But even after being aware of all these facts, Hallman agreed to deliver certain amount of quantity of tea to Mr. Johnson, the defendant. Now Johnson took the tea and later didn't pay to Hallman. Now Hallman brought this case to the court. Now the contention of Johnson was, Hallman was already aware that I am going to do illegal trade with this tea by taking it to England without paying tax, and even after that he supplied these particular teas to me, hence he has committed an illegal act. So the plaintiff, being the wrongdoer, will not get any compensation, which is what Johnson's argument. But Hallman told, I have agreed to deliver the tea in France and the contract was made in France, and as per France law I have not done anything which is against law. So I have done a legal contract of supplying tea in France to another person who is in France. After taking such legal delivery, whatever is Johnson doing with that particular tea is no part to this particular contract. And the court agreed that Hallman's responsibility is only to the extent of completing the delivery in France, and he has done so. Hence, Johnson has to make the payment to Hallman. Here, plaintiff has not committed any wrong because wherever he has performed the contract, he has done his part legally. Whatever is happening after that was in no control of Hallman. That's what he precisely told in the court. I have nothing to do with Johnson after he buys the tea, whether he sells it here or he takes it to somewhere else. It is all his responsibility and his thoughts. I have nothing to do with that, which is what Hallman told, and the court also agreed. So here plaintiff is not a wrongdoer because as per the France law, whatever he has done in that particular case, it was legal. The information that he had was above the contract and nothing to do with this particular contract, which is what held by the court, and that is a very important angle you need to remember. I hope that is very clear, and with that thinking, I am handing over this presentation to Nishan.
Life is like a keyboard. We all need a shift in our life. To get shift, we need to be well prepared. If we aren't well prepared, instead of getting shift, we get oops. With that, I'm concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.